Hi everyone, I am Dr. Shireen Khan. In today's digital age, having a presence on the internet is non-negotiable for businesses. Just like a physical address directs customers to a brick-and-mortar store, a domain name acts as an online address, guiding users to a website. This address, however, is more than just a technical necessity. It's a powerful branding tool, shaping customer perception and influencing their online experience. This is where the concept of trademarks intersects with domain names, creating a complex legal landscape. Trademarks, simply put, are symbols that distinguish one business's goods or services from others. They are valuable assets, representing a brand's identity and reputation. When a business chooses a domain name, it often wants to use its existing trademark, aligning its online and offline presence. This desire for consistency is understandable. A memorable and brand-aligned domain name fosters trust and familiarity among consumers. However, the online world operates differently than the physical one. Two businesses, for instance, can't occupy the same physical storefront. But in the digital realm, two different entities might seek to register the same or confusingly similar domain names. This is where conflicts arise. The increasing significance of domain names in online branding has led to a surge in disputes. Businesses are now acutely aware of the importance of securing domain names that not only reflect their trademarks, but also protect their brand identity from infringement. Understanding the nuances of domain name registration and the potential legal pitfalls is crucial for any business looking to thrive in the digital age.
At first glance, a domain name might seem like a random string of characters. However, it follows a hierarchical structure that is crucial to understanding its function and significance. Think of it like an address. Just as a postal address starts with a specific apartment number, then narrows down to the street, city, state, and country, a domain name follows a similar logic. The rightmost part of a domain name is the top-level domain, or TLD. The most common TLD is .com, but others like .org, .net, and .gov are also widely used. These TLDs denote the type of entity associated with the website. For instance, .com is generally used for commercial entities, .org for non-profits, and .gov for government bodies. To the left of the TLD is the second-level domain, or SLD. This is where businesses typically incorporate their brand name or a relevant keyword. For example, in google.com, Google is the SLD and .com is the TLD. Choosing the right SLD is crucial as it forms the core of a website's address and is often directly linked to the brand identity. This structure is essential for the Domain Name System, or DNS, the Internet's address book. When a user types in a domain name, the DNS springs into action. It translates the human-readable domain name into a numerical IP address that computers understand. This process is vital for directing internet traffic to the correct servers and ensuring users reach their intended online destination. Understanding the structure of domain names is the first step towards navigating the complex world of domain name disputes. It highlights the importance of careful selection and registration of domain names that are not only memorable and brand-aligned, but also legally sound. The landscape of domain name registration operates on a fundamental principle, first come, first served. This means that once a domain name is registered, it is generally owned by that registrant until they relinquish it. This system, while seemingly straightforward, highlights the critical importance of early domain name registration for businesses, especially in the context of trademark protection. Imagine a scenario where a business launches a successful product line branded with a distinctive name. They enjoy significant market recognition but haven't registered the corresponding domain name. A third party, recognizing the brand's popularity, might register the domain name. This act, while opportunistic, might be perfectly legal, leaving the original brand owner in a vulnerable position. Early domain name registration, ideally done concurrently with trademark filing, offers several advantages. It prevents the aforementioned scenario of losing a valuable domain name to a third party. Additionally, it acts as a preemptive measure against cyber squatters, individuals or entities that register domain names containing trademarks with the intention of selling them back to the trademark owners at inflated prices. Furthermore, early registration provides businesses with peace of mind, allowing them to focus on building their brand and online presence without the looming threat of domain name disputes. It is a strategic investment that can save significant time, money, and potential legal battles in the future. In conclusion, the first come, first served principle underscores the importance of proactive domain name registration. Businesses, particularly those with established trademarks or those in the process of developing brand names, should make domain name registration a top priority. This proactive approach is an essential element of a comprehensive brand protection strategy in the digital age. The convergence of trademarks and domain names has given rise to a new battleground for legal disputes. While the first come, first served principle governs domain name registration, it doesn't provide a complete picture. There are several scenarios where the registration and use of a domain name can infringe upon trademark rights, leading to complex legal battles. One of the most common disputes is cybersquatting. This occurs when someone registers a domain name identical or confusingly similar to a well-known trademark, with the intent of profiting from the trademark's reputation. Often, cybersquatters will hold the domain name hostage, demanding a hefty sum from the trademark owner to relinquish it. A famous example is the case of Peterson v. Mars, where the domain name panavision.com was registered by a photographer named Dennis Topin, forcing the renowned camera company Panavision to sue to regain control of their online identity. Another related issue is typo squatting, where individuals register domain names that are deliberate misspellings of popular trademarks. For example, a typo squatter might register Amazon.com to capitalize on users accidentally misspelling Amazon.com. These sites often host malicious content or redirect to competitor websites, diverting traffic and potentially harming the legitimate brand's reputation. Beyond these direct infringements, there are more nuanced scenarios. One is tarnishment, where a domain name is used in a way that harms the reputation of a trademark. For example, a domain name incorporating a famous fast food chain's name might be used to host a website promoting unhealthy eating habits. Such use, while not directly infringing on the trademark, could tarnish its image and goodwill. Competitor abuse is another area of concern. While fair competition is encouraged, using a domain name to mislead consumers into believing they are interacting with a competitor is a violation of trademark law. For instance, a company might register a domain name very similar to their competitors, hoping to intercept their traffic and gain an unfair advantage. These examples highlight the complex legal issues surrounding domain names and trademarks. Understanding these common disputes is crucial for businesses to protect their brand identity and navigate the online world effectively. Seeking legal counsel in case of potential infringement is highly recommended, as resolving these disputes often requires navigating complex legal procedures and precedents.